Good afternoon. This is Judge Andrea Long speaking. I am the lead ALJ conducting the hearing today for this case. On the panel, we have Judges Josh Lambert and Judge Mike Lee. We are the administrative law judges deciding this appeal. We sent out a revised notice last week stating that Judge Lee is replacing Judge Stanley. Mr. Hamilton, do you have any objections to this substitution?
I do not, Your Honor.
And Ms. Woodruff, do you have any objections to the substitution?
No, I do not.
Thank you. So before we go on the record, I wanted to make some additional comments. The Office of Tax Appeals will be conducting today's hearings electronically with the agreement of all the parties. And we have with us today our stenographer, Ms. Alonzo, who's reporting this hearing verbatim. And to ensure we have an accurate record, we ask that everyone speak one at a time and please do not speak over each other. Also, please speak clearly and loudly. When needed, Ms. Alonzo will stop the hearing process and ask for clarification. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. And in hopes of a smooth virtual hearing today, we ask that you take the following considerations. Please say your name before you speak. This is especially important if some participants only have an audio connection or if you're on the same frame or on the same screen so that Ms. Alonzo can see who is speaking. Please not use the chat feature in Webex, and please mute your microphone when you are not speaking. This will avoid any feedback or background noise. If you're appearing by video, you can do this by pushing the microphone icon on the bottom of your screen or by pushing the spacebar on your keyboard. And I don't believe anyone is appearing by telephone. And please note that these proceedings are being broadcast live and any information shared on the screen is publicly viewable. So please do not share any private information on the screen. And if there's any questions during the process, including any questions regarding the technology, please direct those questions to me. If you are disconnected, please contact Claudia Lopez. And just for clarification, Mr. Hamilton, will Mr. Hager be testifying today?
No, Your Honor. It is not my intent or his intent to testify unless there were any questions for him.
Okay, thank you. So the issues, exhibits, and timeline of this hearing have been agreed to and laid out in the minutes and orders dated April 28, 2021. As we discussed at the pre-hearing conference and based on each party's estimates, the oral hearing may take approximately 3 hours. If we are indeed on track to take 3 hours, we will take a 5-minute recess about an hour at about the 1 hour, 1.5 hour mark to give everyone a break. Are there any final questions before on the record, Mr. Hamilton?
No, Your Honor.
Ms. Woodruff?
No, no questions.
Right. Are the judges ready to go on the record?
Yes.
Yes.
And Ms. Alonzo, are you ready? All right, she has given us the signal. We are now ready to go on the record. So, good afternoon. Once again, I'm Andrea Long, the lead administrative law judge for this appeal. We are here today for the appeal of Hager, OTA case number 190-75028. Today is Wednesday, May 19th, 2021, and it's approximately 1:02 p.m. This hearing was noticed to be held virtually via Webex, and we will begin with the parties stating their names and who they represent for the record, starting with appellants.
Good afternoon, Your Honors. Chris Hamilton on behalf of appellants Darren and Claudia Hager.
And I'm Sonia Woodruff on behalf of the Franchise Tax Board.
David Hunter, Respondent, Franchise Tax Board.
Thank you. And this is Judge Long. With me today on the panel is Judge Josh Lambert and Judge Mike Lee, who is replacing Judge Teresa Stanley today. And the parties have stated that they have no objections to Judge Lee being on the panel. The parties have agreed that the issues before us today is whether appellant husband's damage award is excluded from gross income pursuant to IRC section 104A2. With respect to the exhibits pursuant to the April 28, 2021 minutes and orders, we admitted exhibits 1 through 11 for appellants and exhibits 1A through H for FTB. And these exhibits were admitted without objection. Appellants provided a supplemental exhibit log that lists exhibits 1 through 12, which is one more exhibit than listed on the minutes and orders. The supplemental exhibit lists exhibit 12 as amended judgment on special verdict from the Los Angeles Superior Court. Mr. Hamilton, is this the same document that's been admitted as FTB's exhibit B?
Yes, Your Honor.
Okay. So then we're not going to admit exhibit 12. But of course, you are welcome to rely on Respondent Exhibit B or any documents that FTB has submitted.
Understood, Your Honor.
Thank you. We previously granted appellant's request to seal exhibits 6 and 11 without objection from FTB. Appellant's supplemental exhibit log also states that correspondence entitled K. Finley to FTB dated 8/18/2017, which we have listed as Exhibit 1, Tab 7, should also be sealed. Is that correct, Mr. Hamilton?
Yes, Your Honor.
Ms. Woodruff, do you have any objections to sealing this exhibit?
I do not, Your Honor.
Then Exhibit 1, Tab 7 will also be sealed. Mr. Hamilton, in my minutes and orders, I admitted Exhibit 4, excerpts from the trial transcript, which consisted of 22 pages. Your supplemental exhibit shows that additional excerpts from the trial transcript. So the additional ones are 4C, testimony of Neil Tyler, 4D, testimony of Lawrence Gregg, and 4F, the closing arguments of Attorney Love, and now totals 96 pages. Ms. Woodruff, do you have any objections to the additional excerpts?
I do not.
So these exhibits will also be admitted as 4C, 4D, and 4F, as laid out in Mr. Hamilton's supplemental exhibit log. And I will note that only the excerpts from the trial transcript that we have admitted is part of the record, but the entire trial transcript that appellant sent to us on September 17, 2020 has not been admitted. And Mr. Hamilton, have you brought any additional exhibits that you intend to submit into evidence?
Your Honor, not today. However, we would ask that since we provided the trial transcript in its entirety, that it also be a part of these proceedings, though we intend to limit our references today to those identified in the exhibit list.
Well, the trial transcript is quite lengthy, as you well know. So if you can limit them to excerpts so we can follow along, do you intend to have other excerpts that you intend to refer to?
Not for purposes of this hearing, but I believe that for the purposes of the OTA's analysis of this case, the entire transcript is relevant.
Ms. Woodruff, do you have any objections to admitting the entire transcript?
I don't have any actual objections to admitting the trial transcript, but it does seem unnecessary if we've each already excerpted the portions that we intend to reference.
Let's take a 5-minute recess and I'll confer with my co-panelists.
Sure.
Right, it looks like we're ready to begin, but before we go back on the record, I see someone else has joined us in this Webex meeting. It says W8974. Can you please identify yourself? We're going to do another roll call to make sure that everyone is here that's supposed to be here.
Okay, we will start with appellants and their representatives. Again, I have Mr. Hamilton and Mr. Hager. Mr. Hamilton and Mr. Hager, can you hear me?
Can you hear us now?
We can hear you, yes.
Okay.
Okay, great. Thank you. I thought that was me. Okay, now for respondent, the Franchise Tax Board, I have Ms. Woodruff.
Present.
Perfect, and Mr. Hunter.
Here.
Great, and for our panel, I have Judge Long,
I'm here.
and then I have Judge Lambert
I'm here.
and Judge Lee.
I'm here.
Okay, thank you, and that is it.
Okay, give me 1 second to get reorganized before we go back on the record. Okay, we are ready to go back on the record. So we have conferred and discussed that the trial transcript will be admitted, but I'll mark that as Exhibit 12. Just for ease of reference, when you refer to Exhibit 4, we can just refer to the excerpts.
Your Honor, may I ask a question to clarify?
Yes.
I just want to confirm that you're indicating that the whole trial transcript is Exhibit 12, but when referring to the excerpts, I'll refer to Exhibit 4.
Correct.
Thank you, Your Honor.
Your Honor, Hunter here for FTV. I just want to bring something to the panel's attention. In your pre-hearing conference orders, it clearly stated that all exhibits should be in by May.
Mr. Hunter, I cannot hear you.
How about now? Is that better?
Yes.
Okay, I'm sorry. I just wanted to bring something up. I was referring to the pre-hearing conference order that stated that all exhibits must be in by May the 4th of this year, and or else they would not be admitted into evidence unless the showing of good cause is made. So has that showing been made right now in order to enter the entire transcript of the underlying litigation into the record of this case?
Well, I think there might have been a miscommunication at the pre-hearing conference. Mr. Hamilton did say he was going to provide some excerpts, so there might, it seems like there was some miscommunication there. But since FTB has already had the entire transcript since, I think it was September 2020, this should not be new evidence. And we will give it the proper weight that of the evidence for this appeal.
Thank you, Judge Long.
You're welcome. And I also want to mention that we received both parties' timely submitted supplemental briefs, which should also be considered part of the record. And with that, I think we are ready to begin with opening statements. Mr. Hamilton, you've indicated you'd like 30 minutes, and you may begin whenever you are ready.
Thank you. Good afternoon, esteemed judges. Today, we're here to determine whether all or a portion of the $2.5 million in damages that Darren Hager was awarded pursuant to his 2007 lawsuit against the Los Angeles County Sheriff's Department for retaliatory conduct should be excluded from the appellant's gross income per Internal Revenue Code Section 104A2. In order for these damages to be excluded from appellant's gross income, they must have been paid on account of physical injury. Appellants contend that when Darren Hager filed his complaint against the Los Angeles Sheriff's Department for its retaliation against him for blowing the whistle on its employees who were involved in illegal activity, that Darren Hager was not simply suing for his termination and damage to reputation, but he was in fact also suing for his physical injuries, which were directly caused by the retaliation of the Los Angeles Sheriff's Department, its employees, all of which is attributable to the Los Angeles Sheriff's Department. The facts behind the retaliatory conduct that caused Darren Hager's physical injury are summarized as follows. In December of 1999, Darren Hager, who was an 11-year veteran of the Los Angeles County Sheriff's Department, was sworn in as a detective in the Lancaster station. Shortly after his stint at the station began, Darren Hager became involved in a joint DEA-LASD task force. This task force was investigating the manufacture and distribution of methamphetamine in the Antelope Valley area. Due in part to information personnel within that sheriff's station were involved in the local methamphetamine trade and his willingness to truthfully report such conduct. Over the course of approximately 1 year, the task force lawfully gathered evidence through wiretaps and the interview of numerous independent and credible confidential informants. This evidence strongly supported the following allegations. A local deputy, who we will refer to as Deputy X, was known locally as a dirty cop. Deputy X had personal relationships with known producers of methamphetamine in the Antelope Valley area. Deputy X permitted his criminal associates to make and traffic methamphetamine. Deputy X was known to steal narcotics seized from rival drug dealers in police operations and would otherwise steal chemicals used to produce methamphetamine from rival criminals. Deputy X himself owned or operated his own methamphetamine lab. Other deputies working in the Antelope Valley area were also potentially involved with local criminal organizations who were also involved in the distribution of methamphetamine. A deputy who had disappeared over a year before was murdered because he stumbled onto a methamphetamine lab, and Deputy X was involved in the murder of that deputy, who was known as Deputy AJ. Finally, Deputy X had murdered persons whom he believed would report his illegal activity. As part of his duties, Hager and the DEA task force were required to report their findings to the Los Angeles County Sheriff's Department in the Antelope Valley. When the Sheriff's Department learned that its own personnel may have been involved in the local methamphetamine trade and the murder of Deputy AJ, they essentially refused to cooperate with the reasonable requests of the task force. In fact, it appeared that the Sheriff's Department began to actively work against the task force by leaking information regarding ongoing task force operations. For example, in July of 2000, Hager learned that confidential information from his investigation was being leaked to Sheriff's Department personnel and then to members of criminal organizations involved in the production of methamphetamine to help them evade law enforcement. In October 20th of 2000, Hager learned from an informant that Deputy X had warned a major local drug dealer about a pending law enforcement operation to help him keep the narcotics operation concealed. Once the task force had developed a substantial amount of credible, independent information that pointed to Deputy X's involvement in a criminal methamphetamine enterprise and Deputy Ajay's murder, the task force reported this information to the LASD, in part to obtain warrants for a more thorough investigation of Deputy X. These warrants were denied without good reason. Instead, the Sheriff's Department began a pattern of retaliation against Darren Hager that threatened his life and ultimately caused the physical injury that would effectively end his career as an active law enforcement officer. As specifically relevant to Hager's physical injury, the Sheriff's Department retaliated in the following ways. First, the Los Angeles County Sheriff's Department continued a pattern of facilitating links of confidential task force investigation information to LASD personnel, including Deputy X. Second, due to those leaks, Darren Hager received death threats from his LASD coworkers, including Deputy X, who threatened to kill him or end his career as a law enforcement officer. Third, and most specifically pertinent to the issue before us today, is that the Sheriff Department retaliated by repeatedly and unnecessarily responding to Hager's calls for backup by providing him with backup from Deputy X or persons closely associated with him who were known to have threatened Darren Hager's life or who had strong motive to silence or end his investigation. As a result of this, it made Darren Hager's job as an undercover officer almost impossible. As an undercover officer, he was not supposed to detain suspects in his undercover vehicle. It was not equipped to safely detain persons. In fact, it was policy that he would be required to call for a black and white who would properly detain the suspect in the rear seat of a vehicle that had what they describe as a cage, which was safe and prevented escape. It was safe for the suspect and safe for the officers involved. In one instance, Darren Hager called the Palmdale station for backup to protect a hazmat team who was cleaning up a disrupted methamphetamine lab that had been busted. The sergeant who responded to him laughed at him when he told he needed backup. And when he asserted again that he needed backup, he was told, "Sure, I'll send Deputy X." This is the person who had already threatened Darren Hager's life. Hager explained to the sergeant that sending Deputy X created a serious safety issue and simply requested that another deputy be sent. The sergeant again laughed at Darren Hager and told him he wouldn't send anyone other than Deputy X. In another instance, Hager received information indicating that a suspect himself had information about Deputy X's illegal conduct. He also knew that Deputy X was aware of this suspect and that the suspect wanted to leak information about his illegal conduct. To protect the suspect and to preserve any evidence he may be able to provide, Hager tracked the suspect down before Deputy X got to him. When he found where he was, he called for backup so that he could detain the suspect. In this instance, the station responded by sending a deputy who was closely associated with Deputy X, who, as soon as he arrived on scene, refused to allow Darren Hager to participate in the arrest or even be present during the arrest, which was contrary to the normal practice. Because of the allegations about Deputy X and his associates within the department, Hager was concerned for the safety of the suspect and called the station back and asked them to send additional backup. During that time, the suspect barricaded himself in his location and ultimately would only leave the apartment or surrender to Darren Hager. Darren contends that had he not insisted on the additional backup, the suspect would have been murdered. The fact that the suspect would only surrender him supports his safety concerns. Due to these retaliatory threats that Hager received and the repeated dangerous backup situations that the Sheriff's Department put him in, it is believed intentionally, it was clear to Mr. Hager that not only did the Sheriff's Department personnel want to kill him, but much of the Sheriff's Department upper management was unconcerned about the threats or any of these events. Directly as a result of this type of retaliation, Darren Hager suffered a physical injury that would effectively end his career. Specifically, shortly after these other events, Darren Hager was seeking a suspect and apprehended the suspect. Normal procedure would call for him, or would require him, to call for a black and white to secure the suspect in the back of the black and white. Due to the incidents that we've just described, Hager feared that Deputy X or another of his associates would arrive and would make the situation more dangerous, either by, frankly, taking action against the suspect, taking action against Hager, or both. As a result, Darren Hager handcuffed the suspect and put him in the back seat of his car. Since the suspect was not properly secured in the back of a black and white, she was able to escape. She slipped the cuffs, escaped from the vehicle, and this resulted in a pursuit. During the pursuit, Hager slipped, fell, and physically injured himself. The injury resulted in a herniated nucleus pulposus of the cervical spine, chondromalacia in the right knee, and an impingement of the right shoulder, all of which caused Hager a stiff and painful neck, numbness and tingling in the fingers of both hands, numbness in his arms, tenderness and pain in his hand, intermittent loss of knee function and knee swelling that prevented him from performing his normal duties. The injury was a direct result of the retaliation that he suffered at the hands of the Sheriff's Department for blowing the whistle. The Sheriff's Department did retaliate in other ways. They refused to take any action in regard to the threats that were made to him by his co-workers. They refused to investigate the illegal conduct of Deputy X and others. Instead, they investigated Darren Hager. They disparaged Hager internally and to other law enforcement agencies. They leaked his confidential home and personal information to individuals within the department who had threatened to kill him. The retaliation culminated in his termination on false pretenses. That the termination was retaliatory was plain. Up until the time he was terminated, he had received outstanding reviews with the Sheriff's Department during the same years as these incidents that occurred in this investigation. He received awards from the Los Angeles County, the City of Lancaster, the California State Senate, California State Assembly for his exemplary service in this same investigation. His investigation was supported by DEA task force members who were frustrated by the lack of action by the Sheriff's Department based on their investigations. His investigation was also corroborated by prior Sheriff's Department investigations into the disappearance of Deputy Ajay. Now, as we will explain later, when Hager sued the Los Angeles County Sheriff's Department, the complaint was not a typical personal injury lawsuit, and it did not contain in the caption a cause of action for his physical injury. However, as we will discuss later, that isn't required for 104A2 to apply. Further, it ignores the fact that the complaint does reference his physical injury. It also ignores that during the extensive trial on this issue, or on the retaliation, a number of facts and significant evidence connecting the Sheriff's Department retaliation to Hager's physical injury were put in front of a jury who considered them and the reasonable inferences from that evidence. And we contend that it was as a result of the evidence that was presented regarding this injury and regarding its relationship to the retaliation that the jury determined that Mr. Hager was entitled to $2.5 million in general damages. The appellants contend that there was no reason to introduce all of the evidence of Hager's physical injury, the circumstances that caused it, in the detail with which it was presented, except to seek damages for this physical injury. The appellants intend to show you today that according to the relevant applicable law, the complaint, when considered with the evidence and the arguments before the jury and the jury verdict, did make the direct connection between Mr. Hager's physical injury and his damages. Appellants contend that when determining whether damages awarded by a jury are received on account of physical injury, the inquiry must focus on all of the facts and circumstances of the trial, including the complaint, the arguments made during trial, and the evidence reviewed by the jury before rendering its verdict. Appellants contend that the Franchise Tax Board's determination that the $2.5 million is taxable is based primarily on an analysis of the complaint and ignores the evidence introduced at trial that did tie Hager's physical injury to the Sheriff Department's retaliatory conduct. Remember, Darren Hager was injured chasing a suspect who was not properly detained because he did not have backup. He did not have backup because as part of the retaliation for his whistleblowing, the Sheriff's Department had a history of sending Deputy X, the very person who had threatened his life and to end his career, as his backup. It was not safe for him to call for backup. A substantial amount of evidence was produced on this issue during the trial. Appellants contend that the analysis of the Franchise Tax Board is not supported by law, especially after the 2012 changes to the regulations under 104A2, and that a more thorough analysis of the information presented at trial that the jury received when they rendered the verdict is required. Thank you.
Thank you. Ms. Woodruff, you requested 5 minutes for your opening statement, so please begin whenever you're ready.
Thank you. Good afternoon, and thank you, panel, for your time today. At issue today is whether a damage award based on wrongful termination and whistleblower retaliation may be excluded under IRC Section 104A2. That section only excludes damages awarded on account of physical injury or physical sickness. Appellant did previously injure himself by tripping and falling while on the job, as you've heard today. He did not, however, sue his former employer for the resulting neck injury. He received workers' compensation and medical disability payments for that accident before ever suing his employer. His lawsuit did not seek any compensation for a physical injury or physical sickness. He sued his employer for wrongful termination and whistleblower retaliation. And because his claims against his employer had no direct and causal link to a physical injury or sickness, the damage award may not be excluded from income. Thank you.
Thank you. Mr. Hamilton, you have an hour to present your argument. Please begin whenever you're ready.
Thank you, Judge. IRC 104A2 provides that gross income does not include the amount of any damages other than punitive damages received on account of physical injury or physical sickness. The statute actually has a fairly broad scope. It provides for non-taxability regardless of whether the damages that were paid were awarded by a jury through a trial or by a private agreement between the parties. Case law interpreting the statute simply requires that there is a demonstrated connection between a physical injury and the damages received. Case law further provides that when an ambiguity regarding the nature of a payment arises, the most important factor in determining an exclusion under 104A2 is the intent of the payer regarding the purpose of making the payment. And that reference was to Simpson v. Commissioner 141, Tax Court 331 at 340. Further, when the payment arises through a complaint and a trial, the intent in making the payment may be determined or must be determined rather by examining all of the facts and circumstances of the case, including the complaint that was filed and the details surrounding the litigation. When the IRS amended the Treasury Regulation 1.104-1C2 in 2012, they modified this analysis. The change indicates that damages awarded may still be on account of physical injury, even if the statute being sued under does not provide for a broad range of remedies, and that the injury need not be defined as a tort under state law or arise from a personal injury complaint. These changes were expressly intended to avoid a taxing agency determining that damages are taxable if they do not arise from a personal injury complaint or claim, especially when a plaintiff is claiming damages under a statute that does not provide for a broad range of remedies. In this regard, appellants argue that Darren Hager's whistleblower retaliation lawsuit, where the employer's retaliation results in his physical injury, is no different than an automobile accident through which the defendant's conduct results in the plaintiff's personal injury. When considering damages that are awarded by a jury after a trial, we must look to the complaint and all the facts and circumstances surrounding the trial that were before the jury who actually awarded the damages to the plaintiff. Appellants contend that when this body considers the complaint, the evidence produced to the jury at trial, the jury instructions, and the jury's verdict, these support appellants' position that all or a portion of the damages awarded were on account of Darren Hager's physical injury, because they show the reasons why the jury awarded the damages. First, Exhibit 2, Darren Hager's complaint does identify Darren Hager's physical injury. More importantly, it identifies this injury within the following context. During his employment with the Sheriff's Department, Darren Hager participated in investigations that revealed evidence supporting allegations that specific employees of the Sheriff's Department were involved in illegal conduct, including, but not limited to, murder, the manufacture, possession, and distribution of controlled substances. Darren Hager refused to participate in this activity. He protested it, and he attempted to correct it. This is what subjected him to retaliation. Darren Hager's co-workers, who were allegedly involved in this illegal conduct and whose alleged illegal activity was reported, harbored spite, hatred, and ill will towards him. These same co-workers who harbored these feelings towards him intended to destroy his career as a law enforcement officer in retaliation for his whistleblowing. As a result of this, he feared for his safety to the point where he felt compelled to contact the FBI to make them aware of the facts and circumstances and the threats. Certain of Hager's co-workers posed a danger to his personal safety. Hager was placed on medical disability due to a physical injury he suffered on duty. Each of these things are identified in the complaint. For reference, they are also the same references that are made in our recent briefing to the precise lines and pages of the complaint. Mr. Hager could not expressly plead all of the facts surrounding the retaliation that resulted in his physical injury, because it would have provided the defendant with a potential defense to the retaliatory termination claim. However, there's nothing in 104A2 that requires this. To resolve this issue and to ensure that he was able to recover from damages for his physical injury, Hager instead determined to introduce a substantial amount of evidence at the trial that directly connected his physical injury to the retaliation he was suing for. He presented this information to a jury so that the jury would have a basis for awarding him damages on account of his physical injury. At trial, the following evidence was produced regarding Darren Hager's physical injury and the circumstances through which it occurred. First, there's Exhibit 4, where Hager provided testimony regarding the circumstances of his personal injury on the job, which resulted from detaining a suspect without proper backup, pursuing that suspect, and tripping and falling during the pursuit. It also describes his physical injuries and resulting pain and discomfort. Additionally, Dr. Kreitenberg provided testimony during trial. So again, this is also Exhibit 4, pages 2846 to 2853. Dr. Kreitenberg's testimony referred to the circumstances through which the injury occurred, again, contemporaneous and to the time of the injury and provided in the trial. And this testimony independently verified that as a result of this work-related injury, Hager suffered, of this retaliation, Hager suffered multiple injuries to the neck and his wrist and his knee, resulting in persistent neck pain. Hager also introduced the LACERA records, and this is Exhibit 3, the LACERA Physician's Examination and Findings, as an exhibit during the trial, which provided the report of Dr. Ron Pizitz, who summarizes the similar corroborating reports of Dr. Robert Shore, Dr. Arthur Harris, Dr. Scott Baden. This report, which consists of approximately 15 pages, identifies in detail the physical injury that Hager suffered at work, diagnosed as herniated nucleus pulposus of the cervical spine, carpal tunnel syndrome, chondromalacia in the right knee, impingement of the right shoulder, all of which caused Darren Hager significant neck pain, numbness, tingling in the fingers of both hands, numbness in his arms, tenderness, pain in his hand, intermittent loss of knee function, knee swelling, and ultimately would cause an end to his activity as a law enforcement officer. Therefore, you really can't say that there wasn't a lot of evidence of this injury before the jury. Further, during the trial, multiple witnesses provided testimony to the effect that Darren Hager's investigation revealed substantial illegal conduct of Deputy X, including the manufacture and sale of methamphetamine, the personal use of methamphetamine, stealing seized narcotics for personal use, the murder of another sheriff's deputy to cover up his involvement in a methamphetamine operation. These witnesses and their testimony are summarized in Exhibit 4, pages 3925 through 3936. The testimony underlying, or pardon me, the evidence underlying that testimony was supported by somewhere between 22 to 23 independent confidential informants. Hager also introduced Exhibit 6 at the trial, which showed Mr. Hager's reasonable fear for his safety if he were to call for backup. First, sheriff personnel were alleged to be leaking confidential information about his confidential investigations to thwart Hager's investigations. That's Exhibit 6, page 5. Deputy X was alleged to have murdered persons who were unlikely to uncover his alleged wrongful acts. Exhibit 6, pages 8 through 11. A very specific allegation that one of the officers who was allegedly involved in illegal activity was leaking information regarding Hager's investigation to violent criminals for the direct purpose of causing physical harm to Darren Hager. Exhibit 6, page 53. Los Angeles County Sheriff Deputy personnel made threats of violence against Hager for reporting alleged wrongdoing by those deputies. Exhibit 6, page 83. The Sheriff's Department personnel spread what should have been a confidential investigation and information revealed in that investigation regarding the misconduct of Sheriff's Department personnel to a significant number of individuals who weren't entitled to that information and weren't involved in the investigation. Further, there was specific evidence introduced regarding the threat of danger to Mr. Hager and the suspects when he called for backup in retaliation for his reporting. The best example being that when, and it's located in Exhibit 6, pages 37 through 40, when Darren Hager called for backup, a local station sent a deputy friendly to Deputy X who attempted Hager Mr. Hager from contacting the suspect at all. To resolve the situation, Darren Hager was forced to call for additional backup. The suspect barricaded himself in and refused to surrender to anyone else other than Darren Hager, supporting his concern that Deputy X and his friend intended to kill or otherwise make the suspect disappear. In summary, the appellants contend that during the trial, Mr. Hager, through his attorney, presented substantial evidence that the Sheriff's Department's retaliatory conduct included allowing Sheriff's Department personnel, including Deputy X, to make death threats against Darren Hager, that the persons who threatened him were allegedly involved in the murder of another sheriff's deputy to keep their illegal activities secret, that Deputy X intended to kill Hager or physically injure him to end his career, and that when Deputy Hager requested backup, the Sheriff's Department would endanger his life by sending either Deputy X or his compatriots as backup, and that as a result of the foregoing, Mr. Hager could not rely on backup from the Sheriff's Department. Therefore, despite the fact that in his pleading, Mr. Hager had to avoid an express cause of action in the caption of the complaint that tied his physical injury to the retaliation to prevail in his retaliatory discharge claim, Mr. Hager did put substantial evidence in the record showing that due to the retaliation of the Sheriff's Department, he could not call for backup, and he was injured while attempting to detain a suspect when he did not have backup. There was no other reason for Darren Hager to have entered so much testimony and evidence of this work-related injury, other than to support a verdict that awarded him with damages on account of physical injury. After all of this evidence was presented to the jury, the judge told the jurors to consider all of the evidence and to decide what they thought occurred. The judge also told the jurors to decide the facts based on the evidence admitted to the trial. That can be found in Exhibit 4 on page 3904. Further, in California, a jury is required to make reasonable inferences that arise from the facts. And according to California law, those reasonable inferences are just as satisfactory as direct evidence of those facts. Appellants contend that the jury, after considering the evidence of Hager's injury, that it occurred because he was forced to detain a suspect without backup, that Hager was unable to call for backup because of the retaliation he experienced after his investigation was leaked, that the jury knew or reasonably inferred that his career-ending injury was directly a result of the retaliation that he was complaining of and the retaliation for which he was seeking damages. Again, there was no reason to put this in front of the jury except to seek damages for that physical injury. Appellants contend the special verdict also supports this claim. The special verdict awards Darren Hager $2.5 million in general damages. Damages for physical injury are general damages. Appellant's claim is supported by additional credible evidence offered by declarations produced by law enforcement personnel after the trial. These are provided through Exhibits 7 through 10. I won't go into great detail right now, but I encourage you to review them. But I will highlight a few issues. Hager was physically injured while chasing a suspect. Mr. Hager has been threatened that he will be shot by sheriff's deputies or LASD employees. Hager is afraid of being killed by his colleagues because he exposed them. By the way, these are all in Exhibit 7. Hager cannot go back to work because deputies are threatening to kill him. Mr. Hager suffers from constant pain and stiffness of the neck. The cause of Hager's disability is the retaliation of the Sheriff's Department against him. Appellants contend that this was more than adequate to show the direct connection between Hager's physical injury and the damages that were awarded. However, appellants acknowledge that due to his pleading concerns, combined with a verdict for general damages, the reporting of the payment, there's some ambiguity as to whether the general damages Hager received are entirely on account of physical injury. Appellants contend that the tax court case that has previously been briefed, the Domini versus the Commissioner, that's Tax Court Memo 2010-9, which was also relevant to the Office of Tax Appeals decision in the matter of the appeal of Head and Feliciano, supports their position in this case. The tax court in Domini analyzed a damage award from an employer to a former employee where no legal proceedings had been initiated. The matter was settled through a settlement agreement, resulting in damages paid to the taxpayer. There was no complaint and no evidence before a jury. The settlement agreement was ambiguous as to the nature of the damages claimed. Tax court analyzed the evidence that was available. The tax reporting of the employer in paying the settlement, and the fact that the employee had advised the employer of her physical injury before the settlement payment was made. The tax court reasoned that since the payer was aware of the injury, and since a portion of the settlement payment was paid in a manner consistent with damages for physical injury, it was reasonable to infer the defendant intended some portion of the payment to be made on account of physical injury, as required by 104A2. The only contemporaneous evidence of a physical injury was the fact that the plaintiff advised the defendant of her physical injury before she was terminated and before the matter was settled. The tax court determined that based on those two facts alone, it was also reasonable to infer that the employer's attorney identified her physical injury during negotiations with the employer. Again, that was just an inference. Thus, in holding that the damages were received on account of physical injury, the tax court relied on a single fact relating to tax reporting, a single contemporaneous fact relating to the employee's physical injury, and two reasonable inferences based on those facts. Appellants contend that this reasoning applies equally here, even more so, and should yield a similar result, especially after the 2012 changes to the 104A2 regulations. Specifically, Hager's lawsuit did allege a physical injury. It is undisputed that the Sheriff's Department was aware of his work-related physical injury. The complaint alleged that Mr. Hager feared for his safety due to retaliation by his co-workers and the Sheriff's Department. At trial, the jury heard a significant amount of testimony regarding the retaliation that Mr. Hager suffered at the hands of the Sheriff's Department and its employees, including that certain Sheriff's Department deputies created a threat to Hager's safety if he called for backup. At trial, the jury learned that Hager was injured after these incidents while pursuing a suspect without backup. The jury was instructed to make all reasonable inferences from the evidence in their deliberation. The reasonable inference is that Mr. Hager did not call for backup because he feared for his personal safety and the safety of the suspect. The jury awarded Mr. Hager with non-economic or general damages, again, a class of damages that includes damages for physical injury. The net payment made by the Sheriff's Department to Hager after the appeal did not include any withholding or other indication inconsistent with appellant's contention that all or a portion of the award was made on account of physical injury. The appellants contend that based on the tax court's reasoning in Domini and the Office of Tax Appeals decision in the appeal of Head and Feliciano, that the complaint, the evidence of the injury discussed at trial, the verdict, and the tax reporting of the payment by the Sheriff's Department is sufficient to show that the jury connected Mr. Hager's physical injury to the defendant Sheriff Department's retaliatory conduct, and that based on the foregoing, the jury awarded Mr. Hager damages on account of his physical injury. That is all.
Thank you. I will turn to my panel members to see if they have any questions. Judge Lee?
This is Judge Lee. I have no questions for appellants at this time.
Judge Lambert?
Hi, this is Judge Lambert. I have a couple of questions, I think. I think you already kind of discussed this, but are you saying that the entire amount should be for physical injury, or that there should be some sort of allocation?
Well, the Franchise Tax Board's determination was that no amount was on account of physical injury. So I would suggest that at this point our position is that that's not a reasonable determination.
If hypothetically, how would we determine, would you say, an allocation in this case, or is there a way to say that the entire amount is physical injury, or what basis would we go on to make an allocation?
Well, I don't understand that to be the issue before the panel currently, but I think that would be the result of a process occurring after this hearing to identify a reasonable and objective basis to determine how to apportion the damages. If there is a portion of the damages that is not on account of physical injury. I don't think we have the information in front of us right now to determine that.
Okay, thanks. Yeah, just asking because sometimes a settlement agreement will allocate the amounts, and sometimes when there's no allocation that's presented, it provides a question that has to be examined.
Judge, I understand and I agree.
Thanks. And another question was, this was addressed and kind of discussed during the protest, where I believe FTB argued that Labor Code 3602 may prevent remedy in this case because if the individual already received payment through workers' compensation. Can you please address that point?
Sure. I would say that probably the best example would be the Simpson case. I'll have to give you the site momentarily, which was a case where a taxpayer brought a complaint that alleged physical injuries that were deemed to be appropriate for workman's compensation but weren't brought within that regime. And the tax court still determined that the taxpayer's damages awarded were on account of physical injury under 104A2. So I would suggest that just because this wasn't within the context of a workers' compensation claim doesn't mean that the jury did not award Mr. Hager damages on account of his physical injury.
Okay, thanks. So I guess, so if the physical injury if he was awarded some damages, some workers' compensation from the physical injury prior to the trial, you're stating that it's this is a separate damages resulting from this retaliation?
Yes, in fact, that's the reason why Mr. Hager, through his counsel, sought to exclude evidence of the workers' compensation proceeding because he did not want the evidence of that proceeding to taint the jury's awarding of damages in this case.
Thanks. And this is Judge Lambert. Just one more question. I appreciate it. Just to clarify, what's causing what exactly in terms of what was argued at the trial? Was the physical injury something that you're stating was that arised from the retaliation, or is it all kind of interconnected?
Well, I'm not sure if I understand the last part of that statement, Your Honor, but I would suggest that, yeah, the retaliation was the threats against Mr. Hager, and in under a wrongful retaliation claim, the acts of the employer or the employee are attributed to the employer, or the employer is responsible for them. So it was the environment that Mr. Hager was in where he could not call for backup that caused him to retain or attempt to detain a suspect without backup, which is what resulted in the injury.
Okay, thanks. Yeah, what I was trying to say was the physical injury kind of one part of the entire complaint, and there was other parts of the complaint that were other types of retaliation. So it's basically the physical injury, and then there's these other incidents that occurred. Or was a physical injury a focal point of the complaint?
I understand, Your Honor. Thank you for clarifying. No, the physical injury was certainly not the sole focus of the complaint. It was an instance of retaliation amongst many other instances.
Okay, thank you for clarifying. Appreciate it. I don't have any more questions.
This is Judge Long. I will save my questions after I hear FTV's presentation. If you are ready, FTV, you may begin.
Okay, thank you, Judge Long. So as you've already heard today, Appellant worked as a deputy sheriff for the LASD until 2003. During that time, he investigated drug cartels in the Antelope Valley. He received information during that investigation that implicated another deputy sheriff in the disappearance of yet another deputy sheriff. And because he accused a colleague of involvement in a potential murder, he claims his employer retaliated against him and fired him from his job. Based on these claims, Appellant sued his employer for whistleblower retaliation and wrongful termination. In the same year that Appellant learned he was to lose his job, he also applied for and received a medical disability retirement based on back and neck injuries sustained in 2002 while on duty. He received those injuries, as you've heard, while chasing a suspect on foot, tripping and sliding on the pavement. These physical injuries were not the basis of his lawsuit, however. In fact, they were not even described in his complaint for damages. The physical injuries were also not present in the jury instructions or the jury verdict. All parties to the lawsuit acknowledged to the court during the trial or in pretrial motions that the physical injuries had nothing to do with Appellant's legal claims against his employer. Finally, even the California Court of Appeal reiterated in its opinion that Appellant's physical injuries had nothing to do with his claims for action in the lawsuit. Now, under Appellant's argument, if a physical injury is mentioned in a trial, that is enough to exclude any award income from a taxpayer's gross income, even if the physical injury is not the harm for which the plaintiff seeks redress. Section 104A2 plainly does not operate that way. Gross income includes all income from whatever source derived, unless a specific statutory exclusion carves out that income from tax. Those statutory exclusions are to be construed narrowly, as stated in the Ogilvy and Schleier cases cited in Respondent's opening brief. IRC Section 104A2 excludes from gross income damages received on account of personal physical injury or physical sickness. Meanwhile, taxpayers must include punitive damages and damages received for emotional distress in income. The language of IRC Section 104A2 is so plain on its face that there really is no need to even look at the legislative history for the statute. Damage awards must be granted on account of physical injury or physical sickness in order to be excluded. But because the appellant has argued that the regulatory changes in 2012 support his position, I will address the legislative history of the statute. Prior to 1996, Section 104A2 did not limit the exclusion to only physical injury or physical illness. In 1996, Congress amended the statute to require that the personal injury or illness must be physical in nature in order to be excluded. The Congressional Committee report for the amendment states that the intention of the legislative change was to include in taxable income all punitive damage awards, as well as recoveries for non-physical injuries, and to provide a bright line standard for the tax treatment of damage awards. Only if an action has its origin in a physical injury or physical sickness will all damages that flow from it be treated as payments received on account of physical injury or physical sickness. In 2012, the IRS amended its regulation under Section 104 to remove the requirement that damages must be based upon a tort or a tort type of right. the IRS explained in Treasury Decision 9573 that the prior language requiring a tort claim was no longer necessary because the 1996 statutory change now explicitly required damages to be based in physical injury in order to be excluded. So this small regulatory change just allowed the regulations to keep pace with a shift in the trends in litigation away from common law tort claims and towards administrative, statutory, or no-fault remedies for personal injury. That regulation change did not relax the requirement that damages must have its origin in a physical injury or physical illness in order to be excluded from income. Appellant argues that if the jury heard any evidence of a physical injury, no matter how unrelated to the basis of the lawsuit, they could possibly have based their verdict on that physical injury. But all of the authority interpreting Section 104A2 requires that the damage award have a direct and causal link to the physical injury in order to exclude the income. Now, courts consistently review all of the evidence surrounding a claim to see whether it is on account of physical injury or physical illness. However, courts place significant weight on the language of a claim for damages, on jury instructions, jury verdicts, or the express terms of a settlement agreement in deciding whether the income is excludable. Here, all of the available evidence proves that appellant's jury award was not on account of physical injury or sickness. First, appellant's complaint for damages fails to describe or mention any physical injuries other than one sentence stating that appellant was, quote, placed on medical disability due to injuries previously suffered on duty, end quote. The complaint's lack of any factual allegation regarding appellant's trip and fall is perfectly rational because the accident was not at issue in his claims against his employer. Neither the instructions to the jury nor the jury's verdict make any mention of physical injury or physical illness or allocation to either of any of those amounts. Next, appellant's own counsel sought to exclude all evidence of physical injury from the trial, arguing that it was totally irrelevant to his claims. The opposing counsel agreed the injury had nothing to do with the claims. However, he succeeded in having that evidence included because it reflected on the amount of lost wages that appellant could claim. So it's important to note that appellant admits he wanted to exclude all of that evidence regarding the accident because he knew that he had violated his department's policies in engaging in the foot pursuit that led to his head and neck injury without calling for backup. And while this decision could be chalked up to mere legal strategy, it proves the point that the physical injury simply was not the basis for appellant's claims or for the jury award. Appellant deliberately chose not to seek compensation for his head or neck injury, and the pleadings in the trial transcripts make that clear. Finally, the California Court of Appeal overturned the damage award for lost wages and back pay. In its opinion, the court stated, Hager's medical disability, that is injury to his neck and back, is unrelated to any wrongful conduct associated with Hager's termination or damage to his reputation. So respondent does not deny that evidence was produced to the jury of appellant's physical injury, but it was not introduced to seek compensation for that injury. The physical disability evidence was admitted in the trial for the limited and narrow purpose of figuring the amount of appellant's potential future lost wages. So in other words, appellant's employer argued that because appellant was already on permanent medical disability when he was fired, he could not ask for lost wages or back pay. And the evidence was admitted to show that he could not perform the duties of his job due to his prior neck injury. Contrary to appellant's argument, the fact that the jury heard some testimony about his neck injury is not sufficient to make the award excludable from income under Section 104A2. The award had to be on account of physical injury or illness, and that's clearly not the case here. Finally, the OTA issued a recent precedential opinion in the appeal of Head and Feliciano, which is directly on point and should be applied to the case at hand. In that case, the taxpayer was a UCLA medical school professor who sued his employer, the UC Regents, for numerous code violations, retaliation for whistleblowing, discrimination, harassment, defamation, and emotional distress. The taxpayer sought compensation for these claims and also stated that he had endured physical and emotional distress as a result of his employer's actions. The taxpayer later settled his claims with the UC Regents, and the settlement agreement noted the taxpayer's claims for physical suffering, but it failed to allocate any amount of money to physical injury or illness. The OTA looked to both the settlement agreement and the complaint in order to find that the taxpayer's settlement award was not excludable under Section 104A2. The settlement release was a broad and general release that made no allocation to physical injury. The complaint placed little emphasis on the taxpayer's claimed physical injury, and so the taxpayer had not established the direct and causal link required for exclusion under Section 104. In the case at hand, the available evidence reflects even less emphasis on physical injury than in the appeal of Head and Feliciano. Appellant makes no allegation of physical injury in his complaint. Physical injury is not named in the jury instructions or jury award. The trial transcript shows that the evidence of appellant's injury was admitted against his own attorney's objections and for the narrow purpose of defeating his claims for future lost wages, rather than proving any of the grounds of the lawsuit. And this should be contrasted with the tax court memorandum decision in Domini v. Commissioner, which appellant places a great deal of emphasis on. In that case, the taxpayer's main claim against her employer was that the employer had created a toxic work environment that exacerbated her symptoms of MS. Her working conditions caused her to have severe MS flare-ups, and she was physically unable to work for over a year due to her employer-created hostile work environment. Further, the settlement agreements segregated the payments into 3 distinct payments with differing tax and reporting treatments. The tax court found that under those facts, at least a part of the settlement award was to compensate the taxpayer for her physical injury. The difference in Domini is that the taxpayer's origin of her claim against her employer was rooted in a physical injury. The employer's actions in creating a hostile work environment directly caused her physical suffering. The settlement agreement memorialized that by segregating the proceeds into 3 payments and applying different reporting treatment. Although appellant now blames his former employer for his tripping and falling during a foot pursuit, this argument is a novel one that was not presented to the jury as a basis for compensation. Appellant cannot show any direct and causal link between his jury award and physical injury because there was none. His damage award is not excludable under IRC Section 104A2 or any other section, and accordingly, he must include it in his taxable income for tax year 2015. Thank you.
This is Judge Long. Thank you. Judge Lee, do you have any questions for either party?
This is Judge Lee. I do not have any questions.
Judge Lambert, do you have any questions?
This is Judge Lambert. I don't have any questions. Thanks.
This is Judge Long. I do have a couple questions. Let me look through my notes real quickly. Mr. Hamilton, can you clarify what your argument about reasonable inferences? Can you restate what the jury, what reasonable inferences the jury was making at the time of their decision?
Sure. The purpose of raising the instructions and the general rule of law in California is to a jury is required to make reasonable inferences is to support that even if you took the position that there wasn't a clear enough connection made based on the substantial evidence of the retaliation and the evidence of the injury that resulted from the retaliation. That language is included, that argument is included to indicate that a juror would have reasonably inferred that the reason why he didn't, Mr. Hager didn't call for backup, which resulted in his injury, was because of the retaliatory conduct. He feared that once again, the sheriff's department was going to send the very same deputy who threatened to kill him to come and provide backup to him. That's what I was referencing that law for.
Understood. Thank you. So regarding Exhibit 7, Mr. Hamilton, is that something that was presented to the jury at the trial?
This was, and I apologize if I indicated the contrary. That was presented in his workers' compensation case.
Understood. Thank you. Okay, I think that's the last question I have for now. I believe we are going to take about a 5-minute recess to give everyone a break and our stenographer a break. So we will reconvene at about 2:25.
Thank you, Your Honor.
Thank you. Okay, I think we're ready to get started again. We're just waiting for FTB to appear.
I'm here, Judge Long. Sonia will be returning shortly. She's on her way.
Okay, perfect. We'll give her a couple more minutes.
Thank you, Judge.
Okay, looks like we're all back. I think we can continue with Appellants Rebuttal. Would you still like to have a rebuttal, Mr. Hamilton?
Yes, Judge, thank you.
Okay, please proceed.
Certainly. You know, I have several things to say. The first is that, you know, I think the Franchise Tax Board is mischaracterizing what is required to show the causal connection between damages and a physical injury. They acknowledge that the pleading rules for 104A2 changed, but they really ignore that application, specifically that you don't have to allege a tort and you can have a physical injury in a case that doesn't involve a tort. And it was expressly to allow that to occur. You know, to the extent their position relies on what isn't in the complaint, the appellants contend that's not the relevant inquiry under 104A2. It doesn't mean that the complaint isn't relevant. It's just one thing that is considered amongst all of the other things. Appellants are arguing that the significant amount of evidence of retaliation that caused Mr. Hager to fear for his life, specifically in a situation where he would need backup, tied to the fact that he was injured in a situation where he sustained an injury without backup, shows the causal connection. The relevant inquiry is the reason why the payment was made. I think it's important to understand that, you know, for damages to be awarded on account of physical injury, we don't even have to have a complaint. So to suggest then that the caption for the complaint must include a personal injury cause of action or a cause of action in tort for a physical injury, you know, is fundamentally wrong. It's not what is required. What is required is that in this instance, when the jury awards the damages, that we be aware of what the jury saw and heard and their instructions. We contend that what the jury saw and heard and their instructions would have caused them to understand that in this circumstance, the reason why there was so much time spent during the trial talking about Mr. Hager's injury was because he sought damages through this complaint for that injury. I think also that the Dominic case has been misrepresented. That case was a retaliation case. It just happened that in that case, the retaliation exacerbated the injuries exacerbated the plaintiff's condition, and that's what caused the physical injury. In fact, that's why we argue that it's applicable here, because it shows how a situation where a person files a complaint for workforce retaliation can result in a claim or can result in damages being awarded on account of physical injury. Obviously, there wasn't a complaint, but ultimately the matter was settled, and the tax court determined that a portion of the damages were awarded on account of physical injury. So to suggest that after that holding, not having a cause of action in the caption, making the connection between the complaint and physical injury and damages is inaccurate. It's not what the law says. In fact, that's why Domini is relevant here. That's why we think it has a lot of value in this situation. It shows that workforce retaliation can result in a physical injury. I think there's another issue, which is to the extent, the Franchise Tax Board has taken this position that Mr. Hager, through his attorney, didn't want to talk about the injury, misconstrues the nature of the motion in limine, and I don't even know that it's relevant given that it wasn't in front of the jury, and it was the jury that determined the damages that were awarded to Mr. Hager. But Mr. Hager's attorney sought to exclude that because it was evidence that he had received damages for his physical injury. He sought to exclude it under the collateral source rule because he didn't want it to prevent him from recovering in this case. So I would say that it actually supports appellant's position here. It's saying this was excluded because we don't want it to taint the jury when they're looking at the evidence of the injury in relation to retaliation here. I think that the reference to the appellate case, really doesn't mean much. This occurred after the trial occurred. It was an appeal of the case, not in any way related to the general damages that we're talking about here. It was an appeal of the economic damages. So a comment made by Mr. Hager's attorney in that regard shouldn't be given much weight, if any, about what this case was about, because those comments weren't contemporaneous to the complaint. They weren't presented in front of the jury. It was a discussion that was had in a trial about a different type of damages that was appealed. And so to use that as a basis to overturn or to suggest that the damages that the jury awarded after hearing all of this evidence of this injury and the retaliation, I think is a mistake, and it should be given little weight, if any. Certainly wasn't something that was in front of the jury when they were deciding to award damages. I think, I would summarize the appellant's position with the idea that, we agree that the appeal of Head and Feliciano applies. We agree that Domine applies, and we think they support the appellant's case here. Unlike the appeal of Head, there was an allegation of physical injury in the complaint. And unlike the appeal of Head, there was a significant amount of evidence about the injury and the circumstances under which it was caused, and the circumstances of the retaliation that Mr. Hager suffered that he contends resulted in his physical injury. And I think that those distinctions speak to exactly what this panel was saying was missing from the appeal of Head and Feliciano. I think that the appellates in this case have shown that when looking at a complaint or a trial that occurs, to focus solely on the complaint or a hyper-technical analysis of specific issues without looking at the overall complaint, the balance of the evidence that was introduced at trial, that's what shows the intent of the person who paid the damages. That's what shows what the jury was intending to award when it awarded Mr. Hager $2.5 million. Oh, I would also add that, based on the Simpson case, the fact that there was a workers' compensation matter does not preclude Mr. Hager from seeking damages for a work-related injury under a retaliatory conduct statute. And in fact, would suggest that the changes to 104A2 that were expressly identified to apply to a complaint under a statute that doesn't have a broad range of remedies applies here. This case is one of the reasons why that amendment was made. That's all, Your Honor.
Thank you. I'll ask my panel members again if they have any questions, starting with Judge Lee.
This is Judge Lee. I have one question for Respondent. And correct me if I'm wrong. I think the jury instruction mentions emotional distress. So I guess my question becomes, is it possible that the jury award could have included emotional distress attributable to a physical injury?
Yes, it's possible. However, it's important to note that the way the law responds to emotional distress from a physical injury is that only the medical costs are going to be excludable. So it's really only the hard costs that a taxpayer incurs, such as medical care and direct costs, that would be excludable.
Okay, thank you. No further questions.
Judge Lambert, do you have any questions?
This is Judge Lambert. I don't have any questions. Thanks.
Thank you. I have a couple questions. So regarding the physical injury, so Mr. Hamilton, is it without any testimony about the physical injury at the trial? Is it your position that there would have been no general damages awarded?
No, Your Honor. I think that in light of the context of the many different allegations of retaliation, that ultimately there would have been general damages awarded, both in the form of Mr. Hager's distress, reputation damage, and his physical injury.
So based on that, how would we make an allocation if there was if it was based on physical injury and based on the distress and damage to reputation?
Well, Your Honor, I agree that that is, to me, the next challenge that has to be overcome. I think that the parties should brief the issue. I think that there has to be a reasonable way of allocating those damages.
And then, so Mr. Hamilton spoke about FTV's position about FTV's reliance on the complaint. So I was wondering if Ms. Woodruff could expound upon that. Is it FTV's position? How much weight do you think we should be giving a complaint? And could we, as Mr. Hamilton said, make a decision without a complaint?
Well, I think it's correct that we need to look at all of the evidence, and that's exactly what we did in this case. The complaint, however, does provide a great deal of evidentiary value, because that is where the appellant, the taxpayer, states exactly what they are requesting and why, and explains the basis for their claims against, their employer or whoever else that they're suing. And in this case, there simply wasn't any physical injury or physical sickness explained or described or really mentioned in any way, other than to, one brief mention of saying that he was already placed on medical disability. It simply wasn't the grounds for his relief. And in order to make a claim under Section 104A2, the award has to have its origin in physical injury or physical sickness. And that's not the case here.
Thank you. And my last question, again, is for FTB, is I'm wondering if you can expound upon the Simpson case that Mr. Hamilton has been referring to, or maybe just in general, could there be a damages award if there was a workers' compensation case as well?
Well, that's an issue that really has not been briefed or looked at in this case so far. So I would need to look closer at the Simpson case in order to answer that specific question. But I think the fact that appellant did not allege his physical injury because he was trying to avoid any kind of issue of, showing that he had already been compensated for his physical injury. Just it proves the point that it just wasn't the basis for his entire allegation, his entire complaint against his employer. He wasn't seeking redress or compensation for physical injury, and that's what Section 104A2 requires.
Thank you.
Judge Long, Hunter here, if I could dovetail on what Ms. Woodruff had to say. If I understand it correctly, the Simpson case stands for the proposition that if a plaintiff received compensation for physical injury under the workers' compensation statutes, they are still allowed to file a civil complaint against their attorney for personal injury. They're not foreclosed from doing so. They get compensated for physical injuries under the state workers' compensation program, but that's not a bar to them filing a personal injury complaint or some other cause of action alleging damages due to physical injury down at the Superior Courthouse. What we're saying is that's not what happened here. And the complaint, you should still look at it, because when you settle a lawsuit or a jury awards damages, they're doing so because you filed a complaint. So in that complaint, you not only have the causes of action, the facts that spell out why the plaintiff is requesting damages, monetary compensation, you also have the prayer that spells out specifically what they're asking for. Here, there's nothing in the prayer that says, I'm asking for, the taxpayer was requesting damages for compensation for physical injury. It simply is not there. So that's the way this panel should also look at this complaint as one piece in this body of evidence. Thank you.
Your Honor, if I may respond.
Yes, I was going to give.
Thank you. The complaint does allege a physical injury. It doesn't state a cause of action in the caption for damages for that physical injury. It does pray for relief according to proof. And while we agree that the complaint is an important form of evidence, it ignores the reality that during a trial, when evidence is introduced and a jury is impaneled, the jury makes its decision based on the evidence produced at trial and the reasonable inferences from that evidence. And we contend that when Mr. Hager asked for damages according to proof and then provided evidence of his physical injury, provided evidence of the retaliation that created it, he proved that he suffered physical damages or physical injury as a result of the retaliation that he was complaining of in the complaint.
One sentence.
Thank you. You may proceed. All right, so I believe that will conclude our hearing, unless Mr. Hamilton, you have anything else to add before we end our hearing today?
One moment, Your Honor. I think we're good, Your Honor. Thank you very much.
Thank you. My apologies. This concludes the hearing. The panel will meet and decide the case based on the briefings, the arguments presented, and the exhibits admitted as evidence today. We will send both parties a written opinion no later than 100 days from today. Thank you for your participation. This case is now submitted and the record is closed. And this also concludes the hearing for our May 19, 2021 calendar. Thank you.
Thank you, judges. Thank you. And opposing counsel.
Thanks, everyone.
Thank you.
Thank you.